I'm Jonathan Melton, a board-certified family law specialist and attorney at the divorce firm of Gailor, Jenkins, Taylor, and Gibbs here in Raleigh, North Carolina. I'd like to give you some insights into the rights of unmarried same-sex couples. Let me go over a few of the most commonly asked questions about this topic. The reason it's important is because since there was no same-sex marriage for so many years, many same-sex couples have questions about their rights if they were never married. A very commonly asked question is, if a same-sex couple was never married, what rights exist to property acquired during the relationship? And the answer is basically none unless the property is titled in joint names. If the property is titled in joint names, then each partner will own an interest in the property. Typically, when a married couple separates, the mechanism for dividing their property is equitable distribution. But equitable distribution is only available to individuals who are married. Unmarried couples who own property will have to either mutually agree upon how to divide the property or file an action to partition the property and ask the court to sell it. Another question I get asked is, what happens to children born of unmarried same-sex couples if both parents are not on the birth certificate? The parent who is not on the birth certificate is going to have to prove that he or she has an established parental relationship with the child before that parent is able to proceed with a custody action. The court is going to look at what both of you intended before your child was born and after your child was born to determine if it was your intent to create a parental relationship between the child and the parent who is not on the birth certificate. Finally, people often wonder, in what ways does the law treat unmarried same-sex couples differently than unmarried opposite-sex couples? The North Carolina domestic violence statute is perhaps the biggest distinction in remedies that are available to opposite-sex couples but not available to same-sex unmarried couples. The statute only covers individuals who are in opposite-sex dating relationships. It explicitly does not apply to same-sex dating relationships. However, the statute does cover individuals who live together like roommates. So many same-sex unmarried couples may be able to avail themselves of the domestic violence protections so long as they live together. If they don't live together, they can't get a domestic violence order of protection. They can only get a no-contact order or a stalking order, and the protections are not as strong. Overall, if you are concerned about your rights, your best course of action is to get married to your partner, or to make sure that both of your names are on your children's birth certificate or on any property acquired during the relationship. Again, I'm Jonathan Melton. Please contact us directly if you need more information. My contact information is included at the end of this video, and please like and share. Thank you.